If you want to pursue asylum in the United States, but your case was dismissed from immigration court, then you need to watch this video because I'm going to tell you about an update that is definitely going to affect you. You see, the agency that handles asylum cases for people who are not in immigration court proceedings, called U.S. Citizenship and Immigration Services, known as USCIS, just made an incredibly important announcement that is going to impact tons of asylum seekers. If you don't follow the instructions in the new asylum guidance, well, your case could be denied and you could be deported. I'm Brian Manning, and I used to be an asylum officer with the government, but now, as an asylum lawyer, I help immigrants all over the country secure their future in America through asylum. Let me know in the comments if you've got an asylum case pending or if you're considering applying. And I'd especially like to hear from you if you've been waiting for an asylum interview for multiple years. Let me know how long you've been waiting. All right, USCIS just released guidance for people who want to get asylum in the United States, but whose case was dismissed by an immigration judge. You see, owing to a recent policy change by the Biden administration, prosecutors from the agency that tries to deport people, which is known as ICE, have started dropping deportation cases against people who aren't a priority for removal. When a case gets dismissed by a judge, the person is no longer in deportation proceedings, which is, generally speaking, a good thing. But if they had an asylum claim pending, then that case disappears when the case is dismissed. So they can't get asylum based on that application. And some cases get dismissed even where the asylum seeker doesn't want that to happen. So what's a person whose case has been dismissed from immigration court but who still wants to seek asylum to do? Well, you can file again for asylum by applying with USCIS. But up until the recent announcement, there was lots of uncertainty around the mechanics of this. My immigration lawyer colleagues and I had lots of questions, most of which have been addressed in the recently published guidance from USCIS. So let's jump over to my computer now so that we can look in detail at exactly how all of this works. Okay, we're on the USCIS instructions page titled How USCIS Processes a Form I-589 Filed After Removal Proceedings Are Dismissed or Terminated. Now, there are two columns here. There's an if column on the left and there's a then column over on the right-hand side. To understand how the process works for you, you've got to discern which of the four categories that you fall into under the if column over on the left-hand side. You see, there are four different rows, 1, 2, 3, and 4, each of which contemplates a different circumstance with different implications for each circumstance over in the then column on the right. Let's look at the first scenario under the if column, okay? It says USCIS never considered an asylum application for you, and you had an asylum application pending with EOIR when your removal proceedings were dismissed or terminated. Now, this is meant to cover people who did not apply for asylum with USCIS, but rather with the immigration court, which is known by its acronym that we see here, which is EOIR, okay? EOIR. Now, this includes people who came to the border without a visa and were put in removal proceedings in immigration court after ICE filed with the court a document called a notice to appear, which is the document that starts deportation proceedings against someone. Now, if you fall into this category, if you applied for asylum not with USCIS, but in immigration court, then you'll look over to the right to the then column to see what the instructions are for you. They say, you may file an updated I-589 on a current version of the form and supporting documents with USCIS. You must submit a new paper form I-589 with current information, including current mailing and residential addresses in the United States. A couple of things to point out here, which go actually for all the four categories that we're looking at today. You've got to use the current version of the asylum application form, known as Form I-589. This means you can't just take the application that you already submitted to the government and then send in the exact same thing to USCIS now, assuming what you previously submitted was the old version of the application form. Now, the current version of the form, as I'm making this video, is from March 1, 2023. You can get the current version of the form on the USCIS website. Now, the second important point is that if you're applying for asylum with USCIS after your case is dismissed from immigration court, you've got to apply on paper. You unfortunately cannot submit an asylum application through the My USCIS web portal. So Moving on, the instructions say, we recommend that you also submit proof that you had a Form I-589 pending with EOIR when your removal proceedings were dismissed or terminated, such as a copy of your Form I-589 stamped received by EOIR or other available documentary evidence of filing with EOIR, and a copy of the EOIR order of dismissal or termination. So be sure to include behind your new asylum application that you're now sending to USCIS those two things: proof that your prior asylum application was accepted by the immigration court and a copy of the judge's order dismissing the case. Okay, next, the instructions tell us that you should also submit any additional or updated information related to your claim for asylum. And then they say to submit your new Form I-589 and supporting documentation to the lockbox associated with your address location. See the Where to File section of the Form I-589 page for additional information. Now, what is this part about the lockbox? What does all that mean? Well, lockbox basically means a mailing address that USCIS uses. It's like a post office box, meaning it's just a place where they receive mail and it's not an actual USCIS office. And in these instructions, USCIS is telling you that you'll submit your asylum application to a certain lockbox dictated by where you currently live, i.e., by your address location, as the instructions awkwardly phrase it. Now, if you click on the hyperlinked text, which we're going to do, then you're going to see this page, okay? And it takes you to this is the general USCIS asylum page. And if we scroll down to the Where to File tab, here it is. And you click on this, you'll expand the dropdown. Then you can scroll down to the Where to File with USCIS by Mail section. Here it says Where to File with USCIS by Mail, okay? Now below that, there's a table that says that if you live in Florida, Georgia, Maryland, New Jersey, Pennsylvania, or Texas, you should send your application packet to the Dallas lockbox. The address is listed on the right, and there's actually two different addresses, with one for mailing done through the U.S. Postal Service, and the other is for private couriers like FedEx, UPS, and DHL deliveries. To be clear, this USPS one up top is like the normal federal mail. These down here are private companies that are not part of the U.S. government, okay? Now, a bit below, we see that if you live in any state or territory other than the states that I just listed a second ago, then you need to send your asylum application materials to the Chicago lockbox. All right, let's go back to the instructions that we started unpacking and continue forging ahead. Now, the next two sentences are extremely important. I'm going to read them and then I'll tell you what they actually mean. They say, if we have evidence that you filed Form I-589 with EOIR before the dismissal or termination of the removal proceedings, we will issue a new Form I-589 receipt notice that reflects your original filing date with EOIR. We will use this date for purposes of the one-year filing deadline, 180-day Asylum Employment Authorization Document, EAD, clock, asylum interview scheduling priority, and age determinations for unaccompanied child principal applicants and child dependents. Now, what is this all about? Well, you see, the date on which you apply for asylum matters for several things. First is the one-year filing deadline, which is a rule that says you won't get asylum if you don't apply for it during your first year in the United States. And there was concern that USCIS might use the date on which you're applying now rather than the date on which you originally applied when you filed with the immigration court for purposes of assessing whether you filed on time in light of the one-year filing deadline. Now, the good news is that with this guidance, USCIS is clarifying that they're going to use the date you originally applied for asylum when you applied with the immigration court. And this is good news because for most people, the new filing with USCIS is going to be made well over 1 year after the person's most recent entry into the United States. And those people would be out of luck if USCIS used the new filing date. But here, USCIS is saying that they'll use the date on which you originally filed in immigration court, okay? And there's actually more good news concerning this filing date issue, this time concerning your ability to work. You see, you're eligible to get a work permit, formerly called an Employment Authorization Document and referred to by its acronym EAD, 180 days after applying for asylum. And people would be starting from square one, i.e. day zero, in terms of that 180-day wait if USCIS were to use the filing date of their new asylum application, which is being sent now to USCIS. They'd have to wait a long time to be able to get a work permit. But these instructions say, no, we'll use the original filing date from when you applied with the court for purposes of the 180-day EAD clock. Okay, the guidance says USCIS will also use the original filing date for child dependents. This is a reference to the fact that an applicant's child can only be included as a dependent in their asylum application if the child is under 21 years old at the time the application is submitted. Now, there are lots of people whose children turned 21 between the time they originally applied for asylum and now when they're going to refile with USCIS. If USCIS looked at the child's age as of the new filing date and they're 21 or older, well, they could not be included as a dependent in the claim. But USCIS is saying here that they'll basically freeze the child's age as of the time of the original asylum application. That's good. Otherwise, many children would age out and would not be able to get asylum through their parents' claim. Now, unfortunately, there is one downside to USCIS using the original filing date. The guidance says that they'll use this date for the asylum interview scheduling priority right here. Under the current framework called the last in, first out approach, USCIS tries to give interviews to people as soon as possible after they apply. People who are further back in the queue are out of luck. They're probably not going to get an interview for many years unless they sue the government to force an interview. By using your original asylum filing date, USCIS is putting you far back in the queue. You're not among the brand new applicants who have a real shot of getting an interview as quickly as a couple months after applying. Unfortunately, it's probably going to be a long time before it's your turn. Okay, we've made it through the instructions for people who applied for asylum with the immigration court, had their case dismissed, and now want to apply with USCIS. By the way, if you want to maximize your chances for asylum success, then be sure to hit the subscribe button and the bell notification so you don't miss the insights that I share on this channel. All right, so now we're ready to turn to the next category of people in the if column of this guidance, which is for people who previously filed an asylum application with USCIS that was referred, forwarded, or transferred to EOIR, and their EOIR proceedings were later dismissed or terminated. So what is this saying? Well, this is for people who applied originally for asylum with USCIS, but who ended up in immigration court without getting what's called a final denial from USCIS on their asylum application. Now, there are two classes of people that normally fall into this category. One is people who came on a visa, applied for asylum with USCIS, and had an interview with an asylum officer, but were found not qualified for asylum and, at the time that negative decision was made, no longer had valid immigration status. Now, in that circumstance, the case gets referred to immigration court. Now, the other class of persons is those who, as this guidance puts it, applied for asylum with USCIS but had their case forwarded or transferred to EOIR, the immigration court. This covers people who came to the border without a visa but had to apply for asylum with USCIS rather than the immigration court. A lot of people were in this position due to a weird administrative quirk that made it so that the immigration court could not accept their application, and the only option to file was with USCIS. And in those cases where that document that I mentioned earlier, called a notice to appear, had been created for a person but not formally filed with the immigration court, USCIS would accept the person's asylum application, but then send it on to the immigration court. Now, these people did not have an asylum interview at USCIS. Rather, their claim was supposed to be adjudicated by an immigration judge. Now, these are the people covered by this forwarded or transferred to EOIR clause in the guidance that we've been reviewing. All right, so now we know who we're talking about. People who applied with USCIS but ended up in immigration court and had their case dismissed by the court. Let's go over to the then column to see the instructions for them. Well, the good news is that everything after the first sentence is pretty much the same as what we just covered. How and where to apply is the same as for the prior category of applicants that we discussed in detail, and indeed it's the same for all four of these categories. And as with the prior category, the operative date for your application, if you fit into this category, will be that on which the original application was filed, not the date on which you're now filing. Now, the first sentence is really important. to note. It says USCIS will accept your newly filed application and then intends to issue a discretionary notice to appear to send the application back to EOIR. What does this mean? Well, it's saying that USCIS will accept your asylum application, but then they're going to put you back into deportation proceedings. They're going to create a notice to appear for you and send it, along with your asylum application packet, over to immigration court. So if this is you, if you previously applied with USCIS, then had your case dismissed by immigration court, and now you want to keep pursuing asylum by applying anew with USCIS, you're going to end up in immigration court. You're not going to have an interview at the asylum office. Rather, you're going to be back in immigration court where the government is trying to deport you. This fact may change the calculus for some asylum seekers. Knowing that you won't get two chances at winning your case, as would happen if you were to first have an asylum interview at USCIS, may cause some folks to forego applying for asylum after their case is dismissed by the immigration court. It's also something that people who are currently in proceedings in immigration court should consider in deciding whether to ask the judge to dismiss their case. Continuing in immigration court will probably get them a decision faster compared to having the case dismissed, applying with USCIS, and waiting for USCIS to transfer the case back to court, and then starting from scratch in the court proceedings. Okay, we're ready for the third category of people who had their deportation proceedings dismissed from immigration court and now want to apply with USCIS. You're in this category if your removal proceedings before EOIR have been dismissed or terminated and you did not file an asylum application with EOIR or previously with USCIS, but you now want to apply for asylum. Basically, this is for people who have never applied for asylum but want to do so now. The crucial thing to note here is the bit that says, since you did not previously file Form I-589, you will be issued a receipt notice with your current filing date. And this makes sense. If you're just now applying for asylum for the first time, then there's no prior filing date that USCIS could use for you. So you're out of luck if you apply more than 1 year after entering the United States, unless you qualify for an exception to the 1-year filing deadline. People in this category will have an asylum interview at the asylum office. Okay, last, we've got a kind of complicated category. You're in this category if you had an asylum application pending with EOIR when your removal proceedings were dismissed or terminated, and you have already refiled a new Form I-589 with USCIS after the EOIR dismissal of termination, your receipt notice filing date reflects the date you filed, your Form I-589 is still pending with USCIS, and you would like USCIS to use the date of your original filing with either USCIS or EOIR instead of the date listed on your current receipt notice. So this is meant to account for people who applied for asylum, had their case dismissed from immigration court, and have already applied anew with USCIS. Like they've already sent in their new asylum application to USCIS after having their case dismissed in court. The thing is, for these people who applied before this guidance that we're looking at right now was created, USCIS issued receipt notices showing the date of application not as the date of the previous application, but rather showing the date of the second application, the date that that application was received. But for the reasons we've discussed, that's not good. People usually want USCIS to use the date of their original first application. So what USCIS is saying with this guidance is, okay, we'll do that. We'll use the original application date. The instructions over in the then column ask you to simply send a cover letter requesting that the original filing date that was on record with EOIR before your proceedings were dismissed or terminated be used. You're going to send this to the asylum office where your case is pending. You also need to submit proof that you had applied for asylum with the immigration court and a copy of the judge's order dismissing the case. I hope this tutorial has helped you understand what you need to do to apply for asylum with USCIS after your case is dismissed from immigration court. If you're ready to take the next step and get help with your asylum case, then call my office today. That number is 713-352-1593. And remember, we help people all over the country, so it doesn't matter where you live. Call us now to schedule an asylum strategy session so that we can help you secure your future in America through asylum. Again, I'm Brian Manning, and it's an honor to serve you in your asylum journey.